Have the members please take their seats so we could begin right away. Once those two sit, I have quorum. Thank you very much. I'd like to call to order the 103rd meeting of the Standing Committee on Citizenship and Immigration. Thank you for our witnesses. As you've probably been told, we are expecting a vote that's going to happen, and bells should start ringing around 11:15. What I would like to propose to the committee is that we hear the witnesses and try to get the 21 minutes of witness testimony in. The clerk has asked for a bus to be available to take us after that, so we could go. We still have lots of time because it's a 30-minute bell. What I'd actually wonder about the witnesses too, because we have a second panel beginning at 12 and we'll return. I'd like to hear from the second panel of witnesses, but then have questions for all six witnesses if you're able to stay in that second hour from 12 to 1. We'll play that by ear as we go. We're not quite sure what goes on in the House, but we'll give this a try. I'm going to suggest actually that we begin with Mr. Rehaag. Rehaag? Rehaag, if you would go for 7 minutes, and then we're going to go to Mr. Powell for 7 minutes, and then to Mr. Tomlinson and Ms. Jordan. Is Ms. Jordan here? Oh, here. Sorry. It's sharing 7 minutes. So, Mr. Rehaag.
Thank you. I'm a law professor. I teach at Osgoode Hall Law School at York University. And my area of specialization is refugee law, and I focus on empirical studies of refugee law, trying to understand what explains outcomes in the refugee determination process. So I've been working with data that I've obtained from the Immigration and Refugee Board through access to information requests about refugee decision-making. I've made that information publicly available over the last 10 years. And I've undertaken statistical analysis on that data and have published articles about factors that explain outcomes in refugee adjudication, including extra-legal factors. Factors like who is the lawyer, what's the claimant demographics, who is the decision maker. Today I'm going to focus on refugee adjudication because of the stakes that are involved in these types of decisions, but one could make similar kinds of arguments about other areas of immigration decision-making. So just a reminder, as you all know, if we get refugee decisions wrong, people can be sent back to countries where they face persecution, torture, or even death. So the stakes are incredibly weighty. So the basic problem that I want to talk to you about is inconsistent decision-making at the Refugee Protection Division. And I want to give you a kind of extreme example. So there was a decision maker, David McBean, who from 2008 to 2010 decided 174 cases at the Refugee Protection Division. He denied every single claim that he heard during this period, even though the average recognition rate at the Immigration and Refugee Board during the period was 50%. So what I did is I did an access to information request to get all of his reasons for his decisions, and I had a law student go through those and code various data points. And it turned out that the decision maker denied most of the claims on the basis of credibility. That is, he just didn't believe the claimants. In fact, in only one out of the 174 cases did the decision maker explicitly say that he believed the claimant, and in that case he was actually sitting on a panel with two other decision makers. He regularly used the phrase, "I simply do not believe that any of the significant alleged events actually happened," and as such, the claim fails. So the question that I wanted to talk to you about today is, what do we do if there's a refugee adjudicator at the RPD who simply does not believe refugee claimants? So this is an extreme example, and it's a few years old now, but the problem of inconsistent decision-making continues. So based on data that I obtained for 2017, just to give you an example, there's one decision maker, Wittenberg, who granted claims 19% of the time, and another decision maker, Boosfield, who granted claims 97% of the time. So 20% on the one hand, 97% on the other hand, huge variations. Now, there's a variety of reasons that might explain this, country of origin and other factors, but when I do the analysis on the data, even when you account for those factors, massive variations persist. One can make the same point about the Refugee Appeal Division. So again, according to the data that I obtained for 2017, one decision maker, Bebington, granted appeals of refugee decisions 8.2% of the time. Another decision maker, Cote, 61% of the time. So 8% versus 61%. Again, huge variation. And I could run through similar statistics at the federal court level. So what we see here is that there is a problem. The problem is subjectivity in decision making in refugee adjudication. Essentially, outcomes and claims hinge in part on the luck of the draw. So what do we do? Well, I want to say two things that we shouldn't do. One is we should not, or I guess three things we shouldn't do. One is we should not remove decision making from the RPD and move that to another location internal to the department, for example. Subjectivity can't be fixed that way. My data shows that across institutional contexts, subjectivity persists. So I think it's really important that that inconsistent decision-making not be used as a reason for moving decision-making from the IRB to other bodies. Second, I don't think it's time to revise the complaints system right now. I'm not sure that the complaint system can actually deal with the subjectivity, but more importantly, the complaint system is actually quite new. It was brought in place in December. I think we need to give that system a bit of time to run its course before we make further changes. And the third thing that we should avoid doing is replacing political appointees, specifically at the Refugee Appeal Division, with political appointees of another stripe. That is, we shouldn't have, when a government comes in that is focused on kind of getting tough on border security, you get one type of appointee who doesn't believe claimants, then another government comes in who's more generous towards refugees, you get a different type of political appointment. What we need to do is we need to depoliticize the process. So that's what we shouldn't do. What should we do? First, depoliticize the process. Make appointments merit-based, not based on political patronage. And my studies have shown that decision-making improved at the RPD when we got rid of the governor and council appointees. That's not because civil servants are better than governor and council appointees. It's because the politics was largely taken out of the RPD appointment process. And then the second thing, and I'm going to end with this, that I think that we ought to do is more guidelines and better training for decision makers, and specifically better training on the issue of credibility. Credibility adjudication in refugee decision-making is incredibly difficult. Credibility assessments are unreliable. People overestimate their ability to reliably detect whether people are telling the truth. And what we really need to be doing is encouraging decision makers to approach credibility assessments with some level of caution. The question should not be, do I believe the claimant? The question should be, could any of my colleagues reasonably believe the claimant? If yes, the claimant should be believed. So my recommendation is guidelines and training to discourage decision makers from making negative credibility assessments, and to encourage them to give claimants the benefit of the doubt.
I'm going to be a tough chair today. Thank you very much. Mr. Powell.
Hi, good morning. Sorry, I'm currently in Geneva. My time's a little skewed. I'm actually here in Geneva as a member of the International Lesbian Gay Association, where members of the community all across the world gather to deal with issues related to the LGBTQI community, and just received a briefing on the crisis situation affecting persecuted LGBTQI people in Egypt, and I'll speak to that in a second. So my name is Kamali Powell, and I'm the Executive Director of Rainbow Railroad. Founded in 2006, Rainbow Railroad is an international focused charity based in Toronto, Canada, with a mandate to help LGBTQI people get to safety. We respond to urgent requests for help all around the world from individuals who have experienced or have been threatened with physical or sexual violence due to their sexual orientation or gender identity. I know many of you at the committee know this, but I do need to remind you that in approximately 72 countries around the world, many have anti-homosexuality laws, and many more have laws that discriminate on the basis of sexual orientation or gender identity. And in too many countries around the world, LGBTQI people are routinely arrested, denied basic rights, are tortured, and even murdered. And while we know that there are individuals in these countries trying to provide a safe haven and environment where people can survive, for others who are facing ongoing daily persecution, access to life somewhere else can be the difference between life and death. And that's where Rainbow Railroad comes in. We provide support to LGBTQI individuals seeking safe haven from state-sponsored violence. And this includes airfare and financial support and travel to costs. Outside of that, we provide information on how people can make an asylum claim through the UNHCR resettlement process or through an asylum claim. Now, since our finding in 2006, we've helped funded travel for over 400 people now, with 200 people in 2017 alone. And this includes support and resettlement for nearly 60 individuals last year who escaped state-sponsored violence in Chechnya. And now, while we're proud of those numbers, the number of requests continue to increase, with nearly 1,200 requests in 2017 and counting every day. I mentioned this in the wake of this testimony because these requests come on an alarming spike of mass detention and persecution of LGBTQI persons in various countries. In 2017 alone, we've received detailed reports on the ground about torture in Azerbaijan, flogging and raids in Indonesia, arrests in Tanzania, and disturbing targeting of LGBTQI people in Egypt following an act of solidarity at a concert, which I just mentioned. And we stay connected to these news stories while receiving the requests daily. Our work involves an extensive process of identifying and reviewing cases of individuals that seek our help, including working with many volunteers on the ground and dedicating staff resources. In sponsoring individuals through the Rainbow Refugee Assistance Program, Rainbow Railroad and other allies across the country have gained significant experience in understanding the issues concerning LGBTQI refugees. And it's this understanding that informs this testimony around the information of refugee boards, appointment processes, and training for board members. What is consistent among people that we help is that they've fled horrific persecution and spent many years hiding. As facilitators to their journey for safety, we've had to guide them through the fear and trauma of leaving their families and communities, many of whom are the actual perpetrators of this violence. And we also try to provide as much support to guide these individuals through their application process. In Canada, these individuals deserve to have their claim heard by decision makers who not only respect their identity, but ensures a level of openness about speaking about their past trauma. And as such, there's an added layer of sensitivity that's required in adjudicating these claims. However, we received an increasing number of accounts of individuals who have been refused asylum claims that demonstrate some systematic problems with the IRB's adjudication process. There's a long history of decision-making that draws upon problematic stereotypes to make such decisions, and especially in determining whether claimants are, quote-unquote, really gay. And this includes assumptions about looking and acting like members of the LGBT community, evidence of self-identification, and an overzealous attempt to reject applicants in the guise of protecting against fraudulent claims, although we know that the number of claims that are actually found not to be credible based on SOGI status is quite low. With that, we applaud the first ever SOGI guidelines meant to help board members make informed decisions. However, there's still more work to be done. In consultation with our allies, we want to present a few recommendations to the Standing Committee. We need multi-day regular training for IRB members involving individuals with lived experience as refugees and newcomers. We demonstrated in consultations with IRCC that civil society has a role to play, and we want IRB to continue to partner with civil society members, agencies, lawyers, and particularly newcomers who have especially developed expertise in order to further establish clear guidelines and best practices. We want to make sure that IRB focuses on opportunities for evaluation and feedback and make sure they dedicate adequate resources to training and development. As an organization that helps provide a pathway to safety to hundreds of volunteers facing persecution, there is much at stake for them as their fate lies in the hands of members of the IRB board. As my earlier colleague just mentioned, that sexual minority refugee claims are some of the most sensitive and difficult cases that people look at. And we need to make sure that IRB members have the tools to make properly informed decisions that are empathetic and informed on the unique experiences of LGBTQI members of the community. Thank you.
Thank you. Mr. Tomlinson and Ms. Jordan, who would like to go first?
I can go
Tomlinson?
first. Okay.
Good
morning.
Minutes.
I am a new immigrant to Canada, and I lead the Canadian HIV/AIDS Legal Network's LGBTQI initiatives. I'm privileged when compared to many other LGBT migrants and refugees to this country. Coincidentally, tomorrow I sit my Canadian citizenship test here in Ottawa. As a gay Jamaican, the path to this glorious day was possible because of my Canadian marriage to my husband, Tom. While our marriage led to multiple death threats upon my return to Jamaica, forcing me to flee to Canada, I did not have to endure the challenges of an immigration and refugee board hearing, which so many already traumatized individuals find dehumanizing and unjust. Approximately 400 million LGBT persons live under the threat of criminal imprisonment, violence, or even death. The IRB faces thousands of refugee claimants each year trying to escape persecution in their home country simply because of who they are or who they love. While strides have been made to improve the cultural sensitivity of IRB members, more could be done to improve their cultural competence. LGBT claimants report that the IRB still requires excessive...
I'm afraid I need to interrupt you just for one moment. We have bells ringing, and I need unanimous consent from the committee to continue for 6 minutes while we hear the rest of the testimony, and then we'll break. That gives us 24 minutes. All agreed? Okay.
Thank you. LGBT claimants report that the IRB still requires excessive evidence of self-identification. For example, in one case, the IRB spontaneously asked to examine a claimant's cell phone for proof of communication on a gay relationship mobile app. In another case, social media pictures with opposite-sex individuals were seen as disproving a gay claimant's sexuality. These experiences are both humiliating and wrong-headed. In countries that still criminalize non-heteronormative sexualities and gender expression, it is often too risky to self-identify, and having an opposite-sex partner is often a mask or perceived cure for homosexuality. IRB members have also requested police records as proof of homophobic attacks. However, LGBT people in many countries distrust the police. When they do report homophobic attacks, they can be implicated in illegal same-sex activity. There's also the unfounded belief that Canada's LGBT refugee process is the easiest way to get asylum and is therefore being abused. That is, if you say you're gay, you get to stay. However, to date, the IRB has only found 3% of LGBT refugee claims to lack credibility. So this is hardly an epidemic of abuse. To ensure that IRB officers improve their cultural competency and fairly assess LGBT refugee claimants, we therefore recommend 3 things. 1, multi-day LGBT sensitivity training for IRB members engaging individuals from refugee source countries with lived experience. 2, meaningful dialogue between the IRB and agencies and lawyers serving LGBT refugees to establish clearer guidelines and expectations. And 3, an opportunity for claimants and/or counsel to provide post-hearing feedback that can improve IRB members' questioning and not adversely affect claims. Canada cannot and must not compound the worldwide discrimination against LGBTQI people while simultaneously touting our human rights track record. The time is now for meaningful IRB reflection and reform. Thank you.
Thank you. Ms. Jordan. Ms. Jordan? Yeah. Just hold on 1 second. I don't believe we have sound.
Can you tell her to turn her mic on?
Yeah, I think you're.
Can you ask her to check if the mic is on?
I think she was checking if it was on.
We can hear.
Welcome back, Ms. Rampel. You've been missed.
Am I audible now?
Sure about that.
Yes.
But
Thank you.
Sorry about that.
I didn't think
Okay.
so.
So Sherilyn Jordan, Rainbow Refugee Chair and Assistant Professor Counseling Psychology at Simon Fraser University. In a world where violent homophobic and transphobic hate persist and may be on the rise, Canada must live up to its promise to be a place of protection. For 17 years, Rainbow Refugee has supported refugees who face persecution of their sexual orientation, gender identity, or expression. We applaud the commitment to LGBTQ refugee protection demonstrated by members of this standing committee from all three parties in its June report, LGBTQ at Risk Abroad, Canada's Call to Action, and by undertaking this study. All refugee hearings are complex, but SOGI decisions present distinct challenges for both refugees and adjudicators. Claimants who have spent their lives hiding to survive and containing memories are required to prove a highly stigmatized identity and to recount memories steeped in shame and trauma. Adjudicators report that these are some of the hardest decisions they face. For over a decade, I've been observing hearings. I've witnessed a wide range of approaches, some sensitive and skillful, brusque and bureaucratic, and a few deeply problematic. As a psychologist, I know that respect matters, not just because it is what Canadians expect from their government officials, but also because respect helps trauma survivors stay clear-minded and present enough to give accurate testimony. I've been pleased to see significant improvements in the respect and fairness of proceedings over the years, and there's still work to be done. Last May, Rainbow Refugee enthusiastically welcomed the release and implementation of the SOGI guidelines. Legal scholar Nicole Laviolette had called for these back in 1996. We've been asking for them since 2001. We were very proud to contribute to several rounds of consultations, and I was honored to design and deliver training alongside lawyer Nicholas Hirsch. Anecdotally, I can tell you this work is already making a difference. The SOGI guidelines specifically direct adjudicators not to rely on Western stereotypes, to think intersectionally, and to consider impacts of stigma and trauma. I'm seeing board members use the language and concepts of Guideline 9 in the hearing room. And this is promising, but there are further steps needed to ensure that respect and fairness are consistent. Follow-up training is needed. Board members need to hear from people with direct experience. They need practice and feedback on how to question the language they use, their analysis, particularly their credibility analysis, and their ability to recognize impacts of trauma. The IRB needs to evaluate how SOGI Guideline 9 is being operationalized and its relationship with Guideline 8 on vulnerability, as well as Guideline 4 on gender and women. In terms of selection, it's critical that new hires be screened for their ability to be both fair-minded and interpersonally respectful with women and LGBTQ claimants. Lastly, I want to highlight a problem that undermines fairness and respect in the hearing process that may be just on the edge of the scope of this study. In the Western region, ministers' representatives intervene in 30 to 40% of hearings, a much higher rate than the rest of the country. These interventions change the tone dramatically, from neutral and respectful to adversarial. I've seen representatives present highly questionable forms of evidence and use belittling questions. At minimum, ministers' representatives should be trained on the SOGI Guideline 9 and held to the same standards of respect as the IRB. I urge the committee to recommend an examination of the role and conduct of the ministers' representatives in IRB proceedings as part of this study or a future study. In summary, significant strides towards fairness and respect for LGBTQ refugee claimants have been made in recent years. But to fulfill Canada's commitment, it's critical that the IRB be resourced to meet this high standard of consistent respect.
Thank you, Ms. Powell. We're going to now suspend the meeting. We have almost 23 minutes to get to the vote. There are 2 buses waiting for members down at the door on Wellington Street to go to vote. We will resume the meeting as quickly as possible, please, to come back. We will begin with the 12 o'clock panel, and we ask any of the witnesses from the 11 o'clock panel to stay, and we'll attempt to ask questions to anybody at that point. The meeting is suspended.
not just the decision makers. Unless the culture of the organization changes, hiring a few decision makers would not have any impact to make IRB a functional organization. This committee needs to look at the organizational structure. I asked this committee to look at the makeup of the organization and who's running it in March 2018. All the major players, the administrators at the IRB, are white, privileged men. In my opinion, and in the opinion of those who appear before them on a regular basis, these are people who are absolutely out of touch with the reality of what happens in a refugee hearing. They are the ones who hire and create policies and make major administrative decisions. This committee needs to ask the minister, when was the last time that a woman of color or a man of color led this organization? I believe it was in 1999. And interestingly, some of the most progressive IRB policies were created at that time. Since then, it has become a stagnant organization. IRB deals with people fleeing from hundreds of countries, different cultures, different norms, and ways of being and behaving. There needs to be an equal representation of different cultures within the organizational level, not just the board members, so that there is an understanding and empathy of how to deal with the people that they are dealing with on an ongoing basis. This committee needs to look at whether the administrators, not just the board members, have an expertise in international human rights, in administrative and refugee law, because these are the ones who eventually will create policies that individual members have to follow. Administrators' knowledge and skill would percolate to the RPD members, as the administrators would ensure to hire decision makers who fully reflect the value of the IRB. Their knowledge and understanding of such concepts will give way to policies that are beneficial to the claimants and make it easier and less traumatic for the refugees to testify. Right now, the board is in the process of creating new policies limiting the disclosure rights of the refugee claimants and providing disclosure. The IRB administrators need to understand that where are these people coming from? Would they have access to documents? Would they be able to get these documents in time? And to put limits on such procedural rights of the claimants is a question that needs to be looked at by this committee.
I need you to draw to a close.
I would ask the members of this committee to question the RPD members past and present, as well as the staff of the RPD, to understand how the board functions. The reason why the decision makers like Cassano, Sterling, McBean, and other terrible decision makers continue to be retained by the board year after year, despite serious complaints made against these outliers. So
I need to cut you off. Thank you. Mr. Brower.
Thanks very much. Thank you for the opportunity to speak with you today about this important study. I'm here for the Canadian Association of Refugee Lawyers, which is a voluntary association of about 300 refugee lawyers, academics, and law students across Canada. I'd like to start by acknowledging and thanking my colleagues from the private bar who've already appeared before you and brought this issue to national attention. It takes an awful lot of work to bring forward a complaint before the board, especially under the old system, and it was their work that has really raised the profile and inspired all of you to sit together to look at how we can solve some of the problems at the board. There are three issues I'd like to touch on briefly in my opening remarks. First, while there's certainly valid concerns about aspects of the way the IRB functions, as we just heard from my colleague, and while the board can certainly be improved, we do need to be very, very careful not to throw the baby out with the bathwater. Second, the IRB has a brand new complaints process that, while again it can certainly be improved, has not yet been tested. In that respect, the timing of the study is less than great, and I would recommend that you reconvene in a year to look at what has happened, but I'll talk about that in a moment. And thirdly, the appointments process. It's connected to the question of training and to complaints. The appointment process could certainly be improved, and we have a number of suggestions. So on the first issue, the IRB enjoys a global reputation as a model of refugee determination. A central quality that's led to that reputation is its expertise and its independence from government. As an expert quasi-judicial tribunal, the IRB manages in large measure, not completely, to avoid the numerous political traps and pitfalls inherent to refugee determination. After all, a core element of refugee determination is determining whether other states are persecuting their own citizenry, and it also involves frequently condemning the actions of other states and their human rights violations. By leaving this determination to an independent tribunal on a case-by-case basis, we avoid, for the most part, turning refugees into political footballs to be kicked around or protected, depending on the proclivities of the government of the day. And we avoid a situation of other countries raising diplomatic concerns that the Canadian government is interfering in their domestic affairs by denouncing their human rights violations. So the independence of the tribunal protects both refugees and the Canadian government. On the complaints process, there have been serious and very long-standing problems with the way the board has dealt or not dealt with board members whose conduct falls below the standard that we'd expect of people holding the fate of vulnerable people in their hands. It's because of this problem that Carl and others, like the Canadian Council for Refugees, have been calling for a new complaints procedure. The IRB heard our call and did develop a new process. We are not saying it is perfect, it's certainly not, but it is new and it is much better than what we had before. We do believe that there are some critical tweaks that could be implemented to make it more transparent and independent. For example, we could make it mandatory to report annually on the nature of the complaints, the steps taken, and the outcome of the complaint, without obviously disclosing identifying information. And we could improve independence by amending Section 5.5 of the policy to give the Director of Integrity more power, the power to refuse, refer, or accept a complaint, while retaining the Chair's power to accept and to refer to an external investigator where the Chair thinks that there is a valid complaint that the Integrity Director didn't think was valid. There also needs to be a range of clear consequences for bad behavior, from training through to removal from any hearing or decision-making role to outright termination. But the new complaints procedure does represent a very significant step forward for the board, and it's one that needs to be tried before being rejected outright, in our view. It's also a process that was within the board's jurisdiction to create, and that avoids undue interference with the independence of decision makers. Other models that have been discussed here are well worth investigating, and I'm hopeful that we'll have at least a couple of minutes to talk about some of them. But we would note that for the most part, some of the other models that have been discussed here would require legislative change or amendment, as well as significant budget, having significant budget implications. Neither of those were within the jurisdiction of the IRB itself to implement. And yet, as we all know from the cases in the media, this is not an issue that either the board or anybody else could afford to put off for legislative amendment. Action is needed, was needed, and is needed, and it's needed right now. So in our view, again, it's important at this point to give the new process a chance to prove itself, and we would commend this committee to come back in early 2019 to assess the outcome. Finally, on the issue of appointments and training, we think that there is certainly more that can be done and must be done to protect the vulnerable people that wind up before the board. For appellate bodies, so the RAD, the IAD, as well as the Immigration Division, given that the majority of people who appear there do not have a right of appeal to the IAD, it's important that members of those divisions have legal expertise and subject matter expertise. But in addition, candidates should be screened for their understanding of discriminatory conduct, including their understanding of appropriate behavior in the hearing room and conduct related to sex, race, culture, sexual orientation, gender identity, and gender expression. Training and complaints are critical, but they only go so far. Who gets appointed and how we deal with bad conduct are critical components to make this board function the way it needs to. An idea that we think should also be explored is partnering with academics for ongoing training roughly similar to that which is provided to judges through the National Judicial Institute. And again, Carl, we have many academic members who are experts in refugee law who would be very happy to work with this committee to develop a protocol. That's it. I'm hoping for an opportunity to discuss some of these options with you during the Q&A. Thank you.
Thank you very much. Mr. Tuthill.
Good afternoon, members of committee. Rainbow Resource Center has a 45-year history in our community. We've been engaged in education for better equity and inclusion for lesbian, gay, bisexual, transgender, two-spirit, and queer people in business, education, and social and government services for most of our existence. We have been seeing newcomers access our counseling program for the last dozen or so years, and in the last 9 months, we've seen 97 unique clients who are refugee claimants or who require settlement services. All of us, those in this room, members of the IRB, and everyone in the world have a gender identity. This is how we see ourselves as male, female, both, neither, genderqueer, two-spirit, or something else entirely. And each of us has a sexual orientation, be we straight, gay, lesbian, two-spirit, pansexual, queer, or again, something else entirely. Are we confused yet? This is why training is so important when working with gender and sexual minority people. Our identities and experiences are as unique as each individual. Each of us also finds ourselves in a geographical, social, and political context which celebrates some gender identities and sexual orientations and marginalizes others. How we understand our gender and sexual identity is unique and personal to each of us, but shaped by the family, community, and society we find ourselves in. My experience growing up as a gay man in Brandon, Souris in the 80s and 90s will be quite different than that of a South Asian gay man growing up in Vancouver East today, or that of a lesbian woman recently arrived from Nigeria with her children. In many cultures worldwide, including here in Canada, there are sexual and gender minority identities that do not fit our Western ideas of being LGBTQ. I ask you to consider this because it may not have been something that you have thought about. I also ask you to consider your own sexual orientation and gender identity within your own context, because this is where good adult education starts, with the learner's experience. I would encourage IRB to follow sound principles of adult education when training members. The need for training around sexual orientation and gender identity and expression is clear. Chairperson's Guideline 9 are a great foundation to understanding the complexities of SOGI realities. I would encourage the department to consider training that is more than one day and is ongoing. The realities and communities of LGBT 2SQ Canadians are dynamic and constantly changing. This is also the case with SOGI minorities around the world. I would encourage training for IRB members that considers the realities of refugee SOGI minorities, but also the reality of Canada's LGBT 2SQ communities and how are the same or different internationally. It is not uncommon in our experience for IRB members to ask why a lesbian has children or is married to a man. Well, for the same reason that a lesbian in Canada may have children, or that a gay man is married to a woman. So many of our transnational realities are similar, yet many are different. Much of what the IRB is looking for in SOGI cases is someone to prove their identity as LGBTQ. Yet, if one's behavior is the reason for persecution, we need to be looking at the persecution faced by the individual, regardless of their identity. Often in SOGI cases, IRB members are looking for inconsistencies in statements. Inconsistencies of SOGI claimants occur as a result of people feeling unsafe. Most in our communities are constantly assessing our safety, deciding who to come out to based on the sense of safety and relevance to the discussion at hand. Imagine being held in a US detention center, often with the general inmate population, and asked to state your basis of claim in public. Would you be comfortable disclosing that you are LGBTQ in such an environment? I was fortunate to have the opportunity to speak with a community member whose hearing took place just before the IRB's SOGI guidelines were released. As a community supporting this person, we were horrified by the invasiveness and inappropriateness of the questions asked. The claimant said to me, "Some questions are triggering, bring back sudden sadness, thoughts, and flashback memories. These can lead to the losing of focus, memory loss, and mental imbalance, and so on. At this point, the claimant is likely to be perceived as not telling the truth," she said. We asked for IRB training to be trauma-informed and consider how the hearing process itself can be re-traumatizing for claimants. It is essential that IRB members understand that the chairperson's guidelines on SOGI claimants, gender-related persecution, and vulnerable persons are interrelated and may all apply to an individual case. While the committee will hear from experts, we strongly encourage you to engage those who are experts in SOGI claims, those who are seeking Canada as a refuge due to persecution based on their sexual orientation, gender identity, and expression. It is integral that these voices be heard by this committee, and even more importantly, engaged in the development, delivery, and evaluation of IRB training related to sexual orientation, gender identity, and expression.
Thank you very much. I invite Mr. Tomlinson and Mr. Rehag to come to the table as well. And we now have time for one round of questioning. And we're going to begin with Ms. Alslav for 7 minutes.
Thank you very much, Mr. Chair. You've all made comments on how critically important the training process is. And I'm wondering if you've had an opportunity to review the training and could give sort of 3 key recommendations on what in the training needs to be improved to ensure that we have a more comprehensive training. And I think that someone mentioned that we probably want follow-on training as well. So it's not a train at the beginning and forget, it's a come back to it afterwards. So just give me sort of briefly what you think those recommendations should look like so that we'll be better informed to determine whether or not the process is working.
So I have spoken with IRB members, and they've described the training. I have not seen the material, and I was advised that it is a 3-hour session, and they're given some material, and they're given a lecture. But my challenge is that I do police LGBT sensitivity training in the Caribbean, my husband, and we know that to make that culture shift that we're asking some persons to make, it's not necessarily malicious, but you're asking them to make a culture shift. That can't happen in 3 hours. Just an example, the training we do when we train in the Caribbean, the first day we don't touch on the subject of LGBT. We literally, as a gay couple, are teaching this course, but we don't tell them that we're a gay couple. He teaches policing, I teach on the human rights aspect. And then the second day, after they spent a day with us, eating with us, getting to know us, etc., then we do the big reveal. And that's when we get the questions, well, why don't you have the same last name? Who is the top? Who is the bottom? Those kinds of invasive questions, which are very inappropriate, but we give them the space to ask because we know that for many people, this is the first time they're getting that opportunity. And so I think it's not so much for me, the content, which I'm sure can be very quickly put together, LGBT 101, but you have to hear from the persons who are experiencing the trauma. Why it can be
and
like
do you
that.
go back afterwards, 6 months, a year later, and
Yes.
and re-evaluate?
Yes, we do. We do have follow-up trainings, and we've done this in 7 countries so far. Funding permitting, we're hoping to do it in more.
Fantastic. Anyone else? I know that Kamali, Mr. Powell, you briefly mentioned it as well. Can you give us some aspects of your training, because clearly that's something you have to deal with on a regular basis just to determine who would get funding?
Yeah, I'm actually going to suggest my colleague Sherilyn go first because they're live in front of much more cases and have seen some shifts recently. So I'll let Sherilyn go first and I can comment afterwards.
Molly. So I was one of the people who designed and delivered the training. I requested a longer period of time than they were able to offer. So 3 hours clearly is not enough. What it does allow is gives people who are inclined to be sensitive the concrete tools to be competent about that. What it doesn't do is address the needed shifts in attitude or values that requires far more sustained training. The elements that I would add in future are far more participatory elements where board members have an opportunity to practice formulating questions, conducting an analysis, and get immediate feedback.
So essentially case study type live practice training. Outstanding, thank
Precisely.
you. I'm sharing my time with my colleague because we don't have a lot of time with you all.
Thank you, and my question is kind of actually along the same lines as Ms. Alslav. She talked about the training process, but do we have a checkup on claims? And my first question will be to Mr. Rehag. You wrote about certain approvals and denials and having certain judges have a higher rating of the usage of the term, on non-credible basis. Do we have a checkup on the system of these judges that are making these claims and?
Well, there's a challenge internally at the Immigration and Refugee Board in terms of responding to variations in recognition rates or in variations in no credible basis declaration rates. And the challenge is the challenge that Mr. Brower raised, which is the importance of preserving the independence of decision makers. So one would not want, I think, to say decision makers have to hit a particular quota. You need to be between 30 and 50%, right? You don't want to do that. You want cases to be decided on an individual basis. So I don't think it would be appropriate to have that kind of direct oversight. What you can do, though, is you can do the kind of training that we're talking about in the SOGI context, but you can do it in any number of contexts. So I would suggest, for example, that the most urgent need is training and guidelines on credibility assessments, because I think that's where, in the SOGI context, but in all contexts, I think that's where the decision-making is going wrong, and I think that's the source of the really massive variations that I talked about.
And you did talk about in your testimony, part of the appointments is to ensure that there's no political ties and no partisanship in that, because as governments change, there may be different appointments, and you need a kind of a system that's more neutral. If you can just elaborate more on part of that testimony that you mentioned.
Yeah, so you don't want to have one government that has a particular view of refugee claimants appointing decision makers who share that particular view, and then you've got a change of government, a whole different view on refugee issues. They appoint very different adjudicators. That creates unfairness because outcomes in refugee applications should turn on the facts and on the law, not on who happens to be appointed as an adjudicator. So I think there are models that you can look at where there's more deference accorded to experts and less of a role for political actors in appointments processes.
Thank you. Ms. Rempel for 7 minutes.
And thank you all for your testimony today. I found it really informative. The challenges of the IRB are numerous right now. It's a system that's under a lot of strain and pressure for the reasons that we discussed today, but also because of the demand on the system. So, I think for us as legislators right now, the goal is to ensure that the question of humanitarian immigration writ large in Canada is one of how, not if. And getting the questions and the issues that you've raised right today is part of that. So because of the vote, we don't have a lot of time today. So I'm going to just ask a series of questions. And what I would hope that you would do is if you could provide written responses to the committee, just to save time. So when I've reviewed the testimony for this committee, the thing that comes up often is the percentage approval rate being one of the key metrics that we kind of look at, on deciding whether or not a judge is fair. And so it's, they've approved so many from here or there. And I just find that a bit of a false metric that could be spun one way or the other. And to me, it seems like the metrics that we need to be looking at is, do we have a clear and transparent framework that can adequately address the situation of persecution of a person in the context of their national situation at any given time? And then how do you ensure that framework is kept relevant and fresh, given that a national situation might change over time? And then from there, asking and sort of having an audit process to see whether or not the system is consistently looking at that process in the right way. I think it's easy for us to say, and I agree with the problem of political appointments, but it's not confined just to this particular committee. You could argue the Supreme Court or any judicial body. So for me, what I would like to go forward from, just again, but hopefully from a nonpartisan perspective, is, do we have that framework right? So do we have the criteria by which that people are making decisions set out in such a way that we can audit it? And then are we feeding the information that we might get from global affairs or other stakeholder groups, or even who those stakeholder groups should be, in constantly looking at the national context? Because we've got members of the LGBTQI community here who have looked at that particular issue, I couldn't agree more. I mean, in the previous study we did, we looked at, we asked the question, well, how gay is gay enough in these hearings? And frankly, that's just completely inappropriate. I love the comment about this. We need to be looking at situations in terms of the incidence of personal persecution in the national context. So my question to you is how do we do that? I think it's oversimplified to say if we don't make political appointments, maybe that is the solution. I don't know. But I still think that what we're missing is a broader, more structured framework that we can audit and evaluate whether or not it's looking. My question to you would be, in the process of that audit, how are we? Do parliamentarians look at that? Is that something that happens internally? What's the role for civil society groups in that? How does training, in terms of sensitivity training, be it SOGI, gender, whatever, how is that feeding into that process? And then in terms of the appointments and training processes, if you were writing up the job description for some of the appointments in this process, what does that job description look like? If you want to even submit a job description for us to look at, I think that that's important too. And then if you were writing up the performance evaluation framework, if you were assessing that person's job, what would those criteria be and why? I really don't have a position on this issue right now. I don't know the answer to a lot of these questions. And for me, this isn't a political activity. I'm wondering, how can we put together a process that fundamentally respects human rights and the rights of refugees, but also it instills public confidence that we're getting it right? I've got two competing news articles on my desks, right? I've got many that talk about the instances that you have brought up with regard to members of the LGBTQI community being just completely inappropriately treated in some of these hearings. And then I've got an article that says that similarities in Nigerian asylum claims based on sexual orientation have Legal Aid Ontario asking questions. The issue shouldn't be a political wedge issue. We shouldn't be making politics out of that. We should be asking, is the system working? And right now, I don't have confidence as a legislator that we have an appropriate framework to make those decisions. So typically, I don't make speeches at committees meetings. I like to ask questions, but I really hope that in addition to the comments that you've made here today, that you would submit a written brief to our committee that has those functional elements attached to it, because that's really what we're missing here. A lot of the testimony thus far has raised the issues, but we don't have a lot of where the rubber hits the road in terms of recommendations. To colleagues who have been working with members of the LGBTI community, that's really what we need at this point, I think, is how does the best practice that you have translate into some of this? I would also look if you can cite in your feedback any international best practice in terms of determination processes for LGBTQI refugees, as well as international best practice on how national governments are feeding in country of origin political assessments into the refugee determination process, right? I mean, an example that we heard in the last study, I think, was a woman who would consider herself straight, but had engaged in sex acts that would suggest her sexuality was otherwise, and this is why she was claiming status, but that she was found to not be gay. So how do we get these, to Mr. Tuttle's comments, these individual experiences contextualized more in a situation of evaluating level of persecution rather than making it about someone's sexual orientation or gender or where they live?
Thank you, Ms. Rempel.
Okay, sorry.
I saw you all furiously writing. The clerk will make available to you the transcript from this meeting so that you can get the essence of the points. If I could just add to that, that in the put them in the context, which I think we're also struggling with, of a quasi-judicial body that is based on individual determination as opposed to group or class determination. And I think that is our issue, that it's not a judicial body with the degree of rigor that goes with that, nor is it a regulatory body. It's a quasi-judicial body, and I think that adds an element of of mystery to our body and how to do that. So if you could put that in that context. Ms. Kwan.
Thank you very much, Mr. Chair, and thank you to all the witnesses for your presentations. I think first off, I think it is important to know that on the whole, I think we're all in agreement at this committee that the IRB are doing a good job, I think, on the whole, and that it is a valuable and an effective system. With that being said, though, it doesn't mean to say that there isn't room for improvement. Many of the problems to which the IRB is faced with is to deal with resources, or more specifically, lack thereof. Take, for example, even in this budget, the IRB was allocated an additional $74 million. But in that context, it only processed 18,000 cases per year with that 74, yes, per year, because it's for 2 years, 18,000 cases per year. And at a time when we have 40,000 cases, more than 40,000 cases in the backlog, with an accumulation of an additional 2,100 cases per month. So it doesn't even deal with half of the backlog that is there. And that is the reality. Now, that said, on to the issue at hand, which is, first, I like to get into the complaint process issue. And Mr. Rahag, in your presentation about the data, I would love it, and if you don't have it at this moment, if you can present that to the committee, I think it would be valuable. In terms of looking at the data, it gives us a glimpse into the situation, and that is to say that from year to year, in terms of comparison of the data that's available to you, how many of the cases are founded to be not credible and denied on that basis? And how many of those cases are groups from the LGBTQI2 community, for example, and then the country of origin breakdown, because I think that will give us a glimpse into the reality of some of the issues that my other colleagues mentioned. The other thing is, I would love to see on that data as well, how many of the cases that were rejected that ultimately went to federal court and were overturned. And that will also give us a sense of the lay of the land, right, in terms of the competence and the level of work being done in terms of situation. And if we can have year-to-year comparisons on that, that would be really tremendous, I think, in terms of our knowledge. I know it's a lot of work. It's like you're a research team for us, and I deeply appreciate that. And I wonder if I can just get a quick comment on the record with respect to this request.
I would be pleased to try to provide some of that information. Thanks for the homework.
Thank you very much. All right. Now, I'd like to turn to the training aspect of the issue, and I think a number of you have made a suggestion. Mr. Tomlinson, Mr. Powell, Ms. Sherilyn have made the suggestion that there should be, for example, multi-day training. And I wouldn't mind for those of you who have commented on this, to expand on that more specifically. When we're talking about multi-day training, are we talking about 2 days, 3 days, 4 days? Like, what are we talking about? And then also the suggestion was that it should be expanded to the minister's representative as well. And is that an agreement from everybody? And I'd just like to get that on record. So we'll start with you, Mr. Tomlinson.
So I certainly think multi-day at minimum should be 2 days, with the first day discussing theory with, as was suggested by Sherilyn, case studies. We found this to be very effective in the work we do in the Caribbean, for example. And then the second day, we must have, in addition to case studies, we must have persons from the affected communities there to interact with the IRB members who are being trained, so that they can, I mean, it won't be a comprehensive exposure, but it at least gives them some better sensitivity. So that's what I recommend. There must be case studies and there must be interaction with the persons who are affected. I don't know if Sherilyn wants to add.
We can't hear.
Can't hear you.
No.
Oh,
Can you hear me now?
Yes.
Yes. Oh.
Perfect. Sorry about that. So to expand on that, absolutely, people need initial opportunity to use the concepts and understand them. And then I would recommend actually video recorded practice sessions that people have an opportunity to observe themselves working and get immediate feedback on how they're asking questions or how they're conducting an analysis. These are methods used in counseling and clinical psychology training regularly, I think judicial training as well. People need in vivo feedback based on their actual performance, not just sort of didactic exposure to concepts. And I would also agree with the involving people who are directly impacted in that early sensitivity training.
Okay, to the other witnesses, anything else to add to what what has been offered?
The only other piece that I brought up in my presentation that I think is important is to also have some level of being trauma informed and sort of how this process can re-traumatize victims, not only SOGI claimants, but anyone that's appearing before the IRB.
Thank you. I only have less than a minute and a half, and I do want to get to the complaint process. Mr. Powell, anything quickly to add to this?
Yeah, the Section 3, understanding the challenges faced by individuals, is pretty, it needs to be given space to be reviewed in depth. And I think that's part of the problem with short trainings, that it doesn't really give enough sense for members to really dive into that section of the guidelines.
Okay, I'm going to get into the complaint process. I understand that, yes, there's a new process in place, but when the IRB actually engaged in this consultation, one of the key issues recommended by, I think, pretty well all the stakeholders was that it ought to be a completely independent process, and yet it isn't. And so even though, yes, it's partway through, should it not be a completely independent process, and should the chair of the IRB not be in a situation where they're making determinations with respect to complaints? And my second question related to that is, for those complaints that are outstanding at the moment, just because a board member has left and those complaints are effectively abandoned, should the IRB not find a way to move forward to complete those complaints and not just let it to be abandoned accordingly? So I'm going to go to Ms. Shapur and then Mr. Bauer.
I believe that the complaint process should be independent and it should not be left to the IRB, because the chairperson is in conflict deciding the cases of their own board members. It's
Thank you.
absolutely...
I need to end that there, sorry.
Can I get
We're going to Mr. Ananda Sangari.
Okay.
Thank you, Mr. Chair, and thank you, panel, for being here. I'm going to be asking very pointed question, and I'm looking for yes/no answers only, just because I'm sharing time with Mrs. Sarai. So the first question is with respect to the new complaint process that's been introduced. Is it important that we try it out for a period of time before a new system comes in, or do we start fresh? So Ms. Sapro, and then we'll go around.
Should not be. There should be a new process.
Carl's position is that it should be tried out. I really hate to disagree with my colleague.
I have no knowledge of the complaint process to date.
I think we should give it some time.
Give it some time.
And for
Having something workable now is important.
And sir? Okay, so thank you for that. Secondly, with respect to background of adjudicators, again, if you're not able to answer, don't feel the compulsion to do so. Do they, from what Mr. Brower said, they need to have legal knowledge and subject matter expertise. So are we talking about refugee lawyers exclusively, or are we talking about different backgrounds of education?
Certainly from our perspective, we're not saying they need to be refugee lawyers, but having a significant complement of refugee lawyers on the board, I think, is important. People with the legal training, they may not have practiced in refugee law, but if they have the training in order to understand the concept and how to run a hearing, I think that would also be adequate in the circumstances.
And how do you balance the order and counsel appointments, which are usually 2 to 3 years, to the fact that a practicing lawyer would have to give up their practice in order to take on that role and then potentially go back to the bar?
Yeah, it's a tough one, but I know many refugee lawyers who have done that, who've decided that it's worth making that commitment for a few years. It's very difficult, but I do think that term limits on GIC appointments are important.
Thank you. And I'll pass my time to Mrs. Sarai.
Sure. Thank you all for coming, and there's a lot of you, so I'll try to see where I can point my questions. It seems apparent that there's several kind of issues that have come up. One is credibility, assessing credibility of witnesses. The judges or IRB members don't seem to have a consistent level of how they address credibility. The second is sensitivity on how they deal with victims of violence or victims of discrimination, especially if they're from the LGBTQ community. And then lack of training. Training seems to be an issue of, most are saying it's a one-day training, and some say the previous course was really hard and there's a high failure rate, and then we have new training which was designed to help you just kind of get qualified as an IRB judge easier. Is that the appropriate mechanism? And the third probably problem we're noticing is the complaint process. Although there is a new system, I think some people are not comfortable with that, as it's the same body doing the same complaint mechanism. Others are saying that we need to test it out before we throw it out. None of you and nobody is stating that the IRB should be dismantled. I think that's pretty consistent. So my question, perhaps I'll start with you, Ms. Sapru, on credibility. When you have, on inconsistency or consistency, if you know you have a judge that's, as we've heard earlier from Mr. Reag, who studied this, that has a 0% of approval of any refugee claim, what do you say to your client when you get allotted with that?
I wouldn't want to traumatize her by telling her about his zero acceptance rate. That just wouldn't be fair. It would put her in a more anxious state. I wouldn't want that.
Because this is about the only, I'm a lawyer and I never practice immigration law, but in any other, in a defense law situation or any others, you will have biases that you'll have a judge who is heavier on punitive damages or heavier on penalties, but you never have one where there's 100% refusal rate versus a 0% approval rate. So I'm just trying to imagine how your clients actually perceive that. And maybe I can ask Rainbow Refugee Society if they've had what their reaction is when they have a case that they're bringing before a judge who has a 0% acceptance rate, what they tell their clients or what they feel themselves. Can't hear her.
Testimony as accurately as possible. And obviously that is harmed by insensitive questions, and I would not ever tell someone ahead of time, you are going into a hearing with somebody who always says no. That doesn't help them. But what we do have to do then is advocate for them to have access to due process, and this includes the RAD and judicial review. This becomes a long, difficult, and expensive process. So effective first decisions, sensitive decision making and questioning saves everyone, protects everyone, protects refugees, protects the system, protects Canadians.
Mr. Brower, as a head of an organization that deals with this, maybe perhaps you can tell me what would you think the appropriate measure should be for when you see a pattern that is very highly skewed in one direction of how to deal with such a judge, or should there be an internal review, should there be an external, or should there be training? What's the appropriate measure of something?
I'm actually going to defer this to Professor Reag. He's done a fair bit of research on this and had some. We talked about this issue, and I really liked his answers. So I'm going to pass it on.
So I think there's a couple of things. I think one is you need to prevent the problem by having a good appointments process, depoliticizing the appointments process, having good training and good guidelines. So I think that's one set of answers. Another set of answers, though, is, as you've alluded to, there's a certain level of subjectivity that's inherent in all legal processes. What's really important in the refugee law process is the stakes involved are incredibly high. Lives are literally at stake. So when you combine those two things, subjectivity and really high stakes, the answer is adequate oversight So making sure everyone gets access to the appeal, making sure that the appeals and judicial review process is functional. And then the second thing that I think that that the committee should think about is in other areas of law with really high stakes, we create asymmetric processes. You think of criminal law, for example, where we decide that we're more concerned about false convictions than false acquittals. I think it's time to have a conversation in Canada about a similar kind of preference in the area of refugee law, and specifically presumptions that would favor refugee claimants just because of the level of
I
subjectivity.
need to cut you off there. Thank you very much. We rarely get two people from Brandon Souris at the table at the same time. So, Mr. Maguire, you've got 2 minutes.
Thank you, Mr. Chair. I do appreciate Mr. Tatil being here today and bringing his views. I know that one of the things you've been been dealing with is the chairperson's guidelines number 9, and you made comments on that. It was put together, as you know, to promote greater understanding in cases involving sexual orientation, gender identity, and a number of areas. Can you expand on your thoughts on that? Is there enough, I guess, in your experience, do the IRB members follow the guidelines? Is it being applied consistently, and are there any appeal processes?
In our experience, it has not been applied consistently, and it's something that as an organization we need to start tracking and reporting on more consistently. I still think that the guidelines themselves are quite good. I think that the problem comes in is that when they are delivered or trained on as simply a policy that must be followed, as opposed to actually understanding how they're written and why they're written down the way that they are and what's included there. We would actually say that the guidelines are useful for us in terms of training, not just for immigration and refugee matters, but across the work that we're doing, because they are so comprehensive. And so, yeah, I think to get beyond what's written down in the paper as policy and really looking into what's written there and why those things are included. And as I mentioned in my presentation, also looking at the interrelationship between what's there and the realities for Canadians, as well as for people who are persecuted overseas.
Thank you. Mr. Chairman, thank you.
Thank you very much. I just don't want the members to move for a minute. I've just got a couple of things I want to let you know. At ease to the witnesses. Just let you know that we have requested a summary of evidence for the committee members as to everything we've heard thus far on the IRB study, and the analysts hope to have it available on April the 12th. So that will be available on the 12th, as well as that comparative study we talked about and looking at other similar bodies. That being said, what I would like from the committee is by end of day on Monday, the April 16th, to have an indication to me and the clerk whether or not you're going to be wanting some more witnesses based on the summary that we see some gaps in or not gaps. So end of the day on the 16th will be, do you want more witnesses? You don't need to tell us who they are, but just an indication of whether or not you're satisfied with the testimony we've had or you want more. I'm leaving the 17th and the 19th available for this study. The 17th for witnesses we've already booked that we're not having this week, no meeting on Thursday. So we'll have witnesses scheduled on the 17th, and then on the 19th, instructions to the analysts. But if you're wanting more witnesses, we may need to bring someone in on the 19th as well. So that's the goal. That, and this will all be in the minutes, so you can double check my my math here. The other thing is that would mean we would start with our study of settlement services on the 24th of April, meaning I need witness lists from the three parties, and I'm going to suggest we have them by Monday, April the 9th, end of day. You've had some time to be thinking about this. Hopefully you've been doing some work. But that gives then the clerk time to get that going for the 24th. Prioritized list. And just your numbers on that would be 22 Liberal witnesses, 11 Conservative witnesses, and 4 NDP witnesses. Ms. Rempel.
Timeline sounds fine. Just in terms of witnesses were here today that did want to present follow-up written briefs, what would the timing be in terms of just the...
I think, though, for us to have helpful information from them that could be, I would like it by the 12th of April as well.
Okay.
that puts some pressure on people. I mean, you're not under law to do that, but by the 12th of April, then we could combine it with the summary of evidence and have that available then for the 16th to have a real review of whether or not we need more time on that. So I need a motion. Ms. Huang, sorry.
Thank you, Mr. Chair. Just also want to make sure, though, that the questions that we put to officials and that the responses are also returned to us prior to us making a decision about whether or not we need additional witnesses, et cetera, et cetera.
Okay, so we've got some of those responses have come in. I saw them this week from IRB. Some came in. Some more are still outstanding. So the clerk will send a note. Again, I'd like that by the 12th. We'll try to get them by the 12th as well.
Okay, thank you.
Mr. McGuire.
Thanks, Mr. Chair. I noticed that you're giving us till the 16th of April to have the last witnesses. Can we find out who the witnesses are that are coming on the 17th?
Yes. So if the clerk will, I think we have 3 already that we have already been submitted, and then we'll just you'll let them know who those are, and then we can look at what holes you are.
Okay.
I know for one thing, I'd like to know: do the Law Societies of Canada provide the kind of training that the lawyers are expecting the IRB to have? Because I have lawyers in my office quite regularly who are quite ill-informed about gender identity issues as well. So they may have a model, or they may have a need to hear that. Things like that. I need a motion passed that in relation to the study on settlement services, members submit their list of prioritized witnesses, including their contact information to the clerk of the committee no later than end of day Monday, April the 9th. Have a mover for that? Leona, all in favor? That's carried. Okay. Any other business? The meeting is adjourned. Have a good constituency weeks.